including our very learned friends who have undoubtable capacity, competence, and experience in the subject matter. I urge you all to engage actively during the next 3 sessions and share your expertise and insights with us. Let us work together to build a brighter future for Zimbabwe. I thank you all.
Thank you so much, Dr. Ontibile. And my apologies for butchering your name. I hope not to do it to anyone else's name. So speakers, discussants, and people who raise their hands, just make sure that your names are easy to pronounce. Otherwise, you fall victim. So thanks so much, Director, for the welcome remarks. I think without wasting any more time, I would like to invite our keynote speaker to come and address us. Our keynote speaker is Dr. Innocent Maja. I hope I'm saying that correct. Is it Maya? Dr. Innocent Maja. Dr. Innocent Maja is the Dean for the Faculty of Law at the University of Zimbabwe. When I think of Dr. Maja, I know he's an academic, but I think of him as a real G. I'm from the tradition of Igbo. I think that is an original. He moves in silence. This man is accomplished, not just in terms of what he has acquired in terms of education, but also because of the fingerprint that he has left on the struggle for human rights and democracy in this country. And he does a lot of this in silence. If civil society is going to get any relief on the NGO bill this year, a lot of that is on account of the intellectual investment into convincing the Ministry of Justice and other actors around what needs to be changed on that bill that Dr. Maja has been leading. Dr. Maja, without wasting any more time, over to you.
Thank you very much, Dr. Lewanika. Allow me to write on the protocol that has been observed by Barbara. I think today my role is very simple. It's just to give a keynote address on the role of the judiciary in elections. And then I will leave the intricate details to the array of speakers that are going to be coming and speaking about different cases, analyzing them, critiquing them, and dealing with those particular aspects. Allow me to recognize Professor Maduku, especially for me as a senior academic, and also has mentored me a lot in my journey. In my legal journey. So allow me to acknowledge him in that particular regard. Now, you notice that the whole issue of regular, free and fair elections is the cornerstone of democracy. And the judiciary also plays a very important role in that regard in safeguarding the integrity and fairness of elections and ensuring that electoral processes are transparent, inclusive, free from undue influence. International good practice emphasizes the importance of judicial independence in electoral processes, speedy resolution of electoral disputes, and protection of human rights. You see this prominent in Article 25 of the ICCPR, Article 30 of the African Charter on Human and People's Rights. You also see a trace of that in the UNHCR General Comment 25, and also Article 17.2 of the African Charter on Democracy, Election, and Governance. What is the role then of the judiciary when it comes to elections? You notice that what is critical here is to perhaps delineate between the pre-election phase, the election phase, and post-election phase, so that you really know what the judiciary's role is in that particular regard. When it comes to the pre-election stage, you notice that one of the roles of the judiciary is to adjudicate on disputes relating to delimitation, which can affect the balance of political power. This ensures that constituencies are drawn fairly and ensures that they do not unduly favor one party. I remember Professor Maduku, that's why I acknowledge Professor Maduku when he got his constitutional law earlier on in the 90s. He was talking a lot about gerrymandering in that particular regard. So that needs to be prevented, and also to make sure that minorities are not discriminated against. I noticed from the program that there will be a session that will discuss that particular aspect. So I'll bother talking about it, but just to flag it, and the experts that have been called will speak about that particular aspect in detail. The other role of the court is to address pre-election challenges such as eligibility of candidates, voter registration, voters' roll challenges. There are a number of cases that have dealt with those aspects, like the MDC Alliance versus ZEC and Scala versus ZEC. So that's one of the roles that the judiciary plays pre-election. And then the third role that it plays in the pre-election phase is to interpret electoral laws. In that regard, there is the Justice Mabedzenge versus ZEC and Minister of Justice. This is a crucial role that the judiciary plays. Of course, there is debate to then say to what extent can they interpret those particular laws. Can the judiciary go as far as exercising their role, positivism role of interpretation, where they can go recommend or to make laws in that particular regard? I'm sure the guys that will be discussing a number of cases will look at that. To what extent can the judiciary go when it comes to interpretation of laws? Now, regarding the election phase, you notice that the court has a number of roles, and one of the roles is to convene trials for those that commit crimes during elections. And then the second role is to promptly respond to complaints of irregularities, such as the handling of ballots, voter intimidation. In this regard, they can be guided by Part 3 of the African Union Declaration on the Principles Governing Democracy in Africa, Article 7.3 of the SADC Principles and Guidelines Governing Democratic Elections, and Paragraph 1 of the Guidelines for African Union Electoral Observation and Monitoring Mission. In terms of our Constitution, your Chapter 7 highlights part of what the court can do in order to promptly respond to complaints that's there. And then you notice that courts can come in and issue injunctions to hold elections activities if the irregularities threaten fairness. This is more or less the role of the judiciary when it comes to the election phase. And then lastly, you notice that when it comes to the post-election phase, there are a number of things again that the judiciary can do. First one is to adjudicate disputes over election results, deal with allegations of fraud and irregularities, and resolve electoral challenges. The petitions can be in two. The first part is the local authority and parliamentary petitions that are provided for in Part 13 of the Electoral Act, and then your presidential petitions that are provided for in Section 93 of the Constitution. You notice that in terms of Section 55(2)(e) of the Constitution, it imposes an obligation on the state to take all necessary measures to ensure the timely resolution of election disputes. This is in line with Article 17, Sub-Article 2 of the African Charter on Democracy. In this regard, you notice that the court may validate or annul election results or make any other order as it considers just and appropriate based on the legal merits, ensuring that the electoral process reflects the will of the people. We have a number of petitions that have been dealt with by the courts. The most almost recent one is the Chamisa versus Mnangagwa decision in 2018. And then you notice again that the other role that the court plays is to protect the political rights plus other civil rights, like your right to fair hearing and access to courts. Interestingly, our section 67 of the Constitution provides a number of political rights that the courts can basically protect in their adjudicative role. You have the right to a free election, the right to a fair election, the right to a regular election, the right to make political choices freely, the right to form a political party or organization of choice, the right to join a political party or organization, and then the right to participate amongst others. So it is the court's responsibility to ensure that those particular rights are protected. And we have a number of instances where political parties and individuals have approached the courts to make sure that that is done. Whether the court is protecting those particular rights or not, I think will be it will then be the issue under discussion. I'm deliberately avoiding giving specific comments because we have specific cases that will deal with those aspects. You'll notice as well that in that particular role of handling disputes, there are a number of disputes that are handled by different institutions. For instance, the issue of voter registration appeals can be dealt with by a designated magistrate in terms of Part 6 of the Electoral Act. The issue of candidate nomination appeals can be dealt with through the Electoral Court, which is Part 11A and Part 12 of the Electoral Act. And then the issue of campaign expenditure disputes can be dealt with by a competent court, which is Part 16 of the Electoral Court. It doesn't indicate which one is the competent court, but from a reading of that, you notice that the magistrate court is a court that's best suited to be dealing with that. And then they also deal with petitions against the results. Like I indicated, these are dealt for parliamentary and local elections. They are dealt with by the Electoral Court. And then for presidential elections, they are basically dealt with by the Constitutional Court. And then for election offenses, you notice that they are in the purview of the Director of Public Prosecutions, and the High Court deals with that particular aspect. The efficacy of how our courts have been dealing with these will be discussed by our panel of judges. In conclusion, you will notice that the role of the judiciary in elections basically is limited, or is basically focuses on four main issues, which are mainly interpreting electoral laws, and then secondly, addressing pre-election challenges, and then thirdly, adjudicating electoral disputes, and then fourthly, protecting political rights. From this moment onwards throughout the day, we'll then have specific discussions on the specific cases that the courts have dealt with, and our able facilitators will analyze the extent to which Zimbabwean courts have dealt with these particular elections. With these few words, I wish you fruitful discussions throughout the day. I thank you.
Thank you so much, Dr. Maja, for those remarks. I'm just remembering that keynotes are not questioned. and I think at the risk of making inappropriate jokes, I will not comment either. So I will need a question or comment on Dr. Maja's remarks, but just to thank him. And because we started a bit late, we are using African Standard Time rather than no more time, I will not waste any more of that and quickly call up our first panel. So can I invite Trust Mahanda, Professor Lamo Matuku, Senator Douglas Monzora, and Mr. Arnold Tunga to join us in front for our first substantive session of the day, which is focusing on delimitation, absolute versus substantial compliance, and the impact of the elections. As they settle down, I will introduce them. There's very interesting nomenclature that was introduced by Dr. Maja when he was saluting Professor Matuku. He says he's a senior academic and mentor. And the things that he described are similar to some of the things that I associate Professor Matuku with, where I am concerned. But rather than calling him a senior academic or mentor, we just used to say Triwana Matuku, full stop. But now I am in possession of language that is more appropriate. I think mentorship, coaching, leadership, and so on. Professor Labo Matuku, yeah, I mean, everyone who is sitting up front really needs no introduction. He is a man credited with having an inner legal eye by his own admission. And he has taught at the University of Zimbabwe. He leads the National Constitutional Assembly as a political party. He has led it as a civic organization. He has worked and advised international organizations, not just in Zimbabwe, but in the region. He is a Cambridge don and is occasionally called back to Cambridge to correct professors when they are teaching people wrongly at Cambridge. Next to him is Senator Douglas Monzora, again a man who needs no introduction. He leads a political party, the MDC Alliance, correct? Yeah, and at some point, I don't know why they are no longer working together. This was the chairperson of the NCA, that was the vice chairperson of the NCA, but now they lead separate political parties. Senator Monzora is a man that I think a lot of us owe a lot in respect of his contribution to constitutionalism in this country. I think none of you guys, I mean, I'm looking at the audience, no one has ever made a film about you. People have made films about this man and the work that he did in the run-up to the new constitution in 2018. Well, I don't think that we should talk about those things. Let's talk about the fact that it has won international awards. I think that, so I'm from an organization that believes in positive narrative building. So it has won international awards and is globally acclaimed. There is so much more that we can say about the senator. But next to him is Mr. Trust Mahanda, who has been a loyal and good friend and kind and steward to the Elections Resource Center, if I'm not mistaken, pretty much from founding, and currently chairs its board. I think on this particular subject that we are discussing, he also represented Senator Douglas Monzora on the case that is cited. Next to him is another man who needs no introduction, and again, someone who we owe a lot in civil society. Director of the Zimbabwe Lawyers for Human Rights, chair of the Voice of, I don't know, some radio station that was banned at some point. He has worked for the International Commission of Juries and serves on several human rights boards global. When I last saw him on Friday, we were together in the United Kingdom, and I was on holiday. He was attending a board meeting. Last year, when this case was underway, he was serving as the senior country representative or director for the National Democratic Institute. So this is an acclaimed panel of lawyers who will take us through the subject under discussion. But as you can see, these are not just lawyers, they are also politicians. So a law professor who is president of a political party, a lawyer who represented me when I was expelled from school in the early 2000s, but who is head of a political party. Mr. Manda, we are finding a position for you in the political party. Arnold Sunga, former member of parliament for Dana Branchkamp. So we're hoping that we will have a balanced, interesting conversation that has got both the legal nuances, but also the political elements. And I see my friend Koskona nodding his head. He's the one who was worried that there would be too much legalese. don't worry, there's also politics. So I will start by inviting Trust Manda to give us a presentation on the cases that have been cited on the program. Then Professor Matuku will come after him.
Good morning, ladies and gentlemen. Yes, we speak as a panel, and I think judges decide even which judge will be the one to write the judgment when they hear the matter. And I have decided, together with Professor Matuku, that I be the one to say, I agree. So the professor will go first, then I will come and either give a dissenting judgment or a concurring judgment. But I don't think there will be any dissension, there will be consensus. So professor will take first, then I'll come. Thank you.
Okay, thank you very much. That's correct that we agreed that I'll start and then come in to add a few points. I should start by really acknowledging this symposium. When I saw the invitation, I thought it was a very good thing, and I believe I'm correct in that. I also need to recognize the Dean of Faculty of Law who gave us a keynote address. Although the moderator said he did not comment, it was an excellent presentation. I think that is allowed. So I thank you very much for that. Then I recognize, of course, Dr. Lewanika, Dr. Bebe, the leaders that are here from various sections. I've seen some colleagues from the Faculty of Law who are here. And then I've seen other faces, I'm not sure who they are, but I need to acknowledge them as well. But I would not start without indicating that even though you say we are mentored and so on, we were our own people that are heroes or my own heroes. Arnold Tsunga is not necessarily in my group, he is actually far ahead of me. And people must know that from time to time. He was senior at the university. They were a class ahead of us, even a bit in the and so on. But not everyone I got ahead of us is ahead. So that is very important for me to say. But Arnold is one of those persons who was ahead and who is ahead. So I want to acknowledge you, Arnold. Saka, when I saw you at Garaba, I realized for the first time that life can be very long. That's what it is for him. He has done a lot of things. I don't think I can count Dragon and a lot. And to still find him among civil society persons and engaged in a very important discussion, I was quite inspired by that and want to encourage you to do so. So possibly, Lewanika kanochida mentor chaicha although wango wachiringana ndiye munhu chaicha wokuteerera and so on, and then continue to work with Arnold. And those are my remarks. My presentation will be short because I know that the panel has persons. Douglas was the real player. He was the litigant in the case, so he was our client. And then his main lawyer was Man. I was asked to assist in that regard in the case here, the delimitation, the one that involved the MDC. Then there was another case where I was a lawyer for the person who went to court. So the two cases that we will discuss. But before I get into those, because I intend to brief, I need to say that the purpose of a constitution is normally not understood by many people, what a constitution does, why constitutions are put in place. Constitutions are put in place for one reason. That reason being that power is very sweet and will always be abused. That is the power is sweet and it will always be abused. It's invariably to always be abused. So what societies try to do is to find mechanisms of limiting the abuse of power. And that mechanism, the primary mechanism for limiting the abuse of power, is to try and put a constitution in place. Constitutions are not put in place to satisfy the real reason for a constitution is to limit abuse of power, because power will be abused. If your constitution fails in that regard, and so on. You should not have. You need to have a constitution in place. It puts all this. So when we look at our rules and look at rules relating to elections, if we put them in that agenda, elections are there to limit abuse of power, so leaders must come and go. There must be a periodic framework where we have elections. So an electoral process is part and parcel of that agenda. We can reduce the whole constitution to that. You can pick every rule. You will see that the reason for the rule, the main reason for the rule, is to limit abuse of power. So when you have the Bill of Rights, the Bill of Rights creates a no-go area for the state. Thou shalt not take away my right to do this. It's because if you don't say so, they will interfere with my rights. And it will freedom of speech, put it in your constitution. There will be people who will want you not to have a freedom of speech. If you don't want to give yourself the right to human dignity, there will be people that will want to undermine your dignity. And so that is the real essence. So there are other purposes. Apanamotara that way, just to make sure that I emphasize the importance of a constitution. So it is why a constitution must always be related to what they call constitutionalism, which is the very belief that we must have limited governance and that we must limit abuse of power. So when we have an election, you try and make it fair, and that it must be free and fair if possible. But our constitution is very good in that regard. In section 155, it sets out quite a number of principles of an electoral system. When you get time, I would recommend that you read that. Sometimes the democracies are not give for this document, but from time to time, they are going on in a sense of our So this is one of the things the reform. So if he wants to celebrate, he can just use section. Some of them don't celebrate point the provision. If you say I wrote the constitution, I was part of those that did the constitution. That must not be enough. Push them to say which provisions would you want us to remember. So the 155 is one of the very good provisions in our constitution. It can be very useful if you have a proper process and so on. What they put in section 155 is what they call the principles of the electoral system. And they set out in section 155(1) that elections must be held regularly, which is a very good point. And they set about 4 subheadings, very good subheadings. 1, peaceful, free and fair. If you were not them, you would have ended there. Then they go to 2, conducted by secret ballot. Then 3, based on universal adult suffrage and equality of votes. That's where we will be in our span of equality of votes and so on. Then, of course, number 4, free from violence and other electoral malpractices. Then after they've done that in subsection 1 of section 155, they then go to subsection 2, where they impose obligations on the state to ensure that these objectives are satisfied. So I find that section extremely useful. So Maja was referring to when he was taught, I think, I don't know when we taught him, but I told it. Maswanata ago emphasize ish. But these are the things that would be emphasized these days. So the next 2 days will be coming and say, yeah, the Telegraph section 155 Katawi as my elections. Is that clear? If you look at the very beautifully done provision, Douglas, EOS section 155, and so on. So you get there, it says that everything else that comes must be anchored on that. Now, the unfortunate thing about section 155 is that it is not understood by our courts. So one of the disadvantages that you get in any country is to have a good law which is not understood by the courts. Une law right, but my courts are I understand. As Batin. So we used to have a Skadawaganaga, but I so we take them to all the Wararagunok and so on. So you get someone very beautiful. Here, just take those people. Which will you the time done a very good thing. Governor is a very good person. But just help that person, get them out, and give them better opportunities. Okay, what I'm saying here is that one of the disadvantages of our constitution is that the judiciary here does not understand the depth of this document. And that is worsened. Recently, we had some appointments to the bench and so forth. I don't know, they made a very good judge, I think. So they appointed some people to be judges. And then this was a public process. And then a public process where you all watch the interviews, you watch the questions, you also, if you look at the demeanor, the public is participating. But the persons who appointed them didn't have any regard to the principles of a public process. What is the importance? Why does the Constitution insist on a public process? The reason for that is not understood by not just by judges, but by many Zimbabweans. Because after that appointment, what I can tell you, I came across everywhere. By the way, I did one, I should go complain. What kind of appointment is that? But I don't any public statement or public outburst, or any comment from the public, which would say, look, we were also following the proceedings, Mr. President. We do not understand your appointment 1 or appointment 6 or appointment number 10. Munopama numbers, so I'm putting my pictures, I'm waiting my picture, my judge, I got put away. Never interview, I say, my pictures, I got not. Because I go unaita mapicha este mwapa manamba 1, 2, 3, 4, 5. It's not tenderwise, it is with advocate. This one. Most of the judge 1, judge 10, judge 11, and Modo Komena Mama Maki, as you know, now, these are things I thought would happen. And that's the reason for the Constitution providing a public process. It means the public has a right to comment. It has a right to question an appointment. Now, so what was happening with that public process? Some of the most difficult things, even that was topic, and I'm just going to go into story. All right, is that it was very possible for the people who were asking questions not to know the answers. Because when you then get my appointment, some questions were appointed. So we don't know what the questions were all about, and so forth. And this is the point. Please, if you want to remember, what I'm saying is that a constitution can only be as good as those that are working on the constitution, both the public, the judiciary, and everyone. You can have a very good section 155, but if you do not have people that defend that, and so on, then it won't make sense. If you do not have people who understand why the Constitution put a public appointment process, who would make the appointers accountable, then and so on. Perhaps you expect Dagi to go to court now and take the president, and then pick appointment and say this candidate did very poorly, we want the court to nullify the appointment and so forth. You shouldn't expect them to be doing that, but members of the public would be allowed to do so, and so on. Now, turning to my last portion, which is the delimitation process. The Constitution appreciates that the electoral system that is provided for in our Constitution is based on constituencies, so far as Parliament and other players are concerned. So Parliament and local government, based on constituencies. Only the presidential election is not based on constituencies. For that kind of an election, it is very important that the boundaries of constituencies be done properly so that we maintain what is called in the Constitution an equality of votes. And so the principles are set out. When you are doing that, you are promoting a free and fair election. But most importantly, the Constitution then provides in section 67 for a fundamental right that it gives every citizen, not groups, but every citizen has a right to a free election, to a free and fair election. That I would need to read this provision so that we get to understand what this issue in court was all about. Section 67 provides what are called political rights And then section 67, subsection 1, paragraph A says, every Zimbabwean citizen has the right to free, fair, and regular elections for any elected public office established in terms of this constitution. It is that right that is at stake when you are dealing with delimitation. Your right to free, fair, and regular elections. So if you contend that for the election to be free and fair, and there ought to be a proper and credible delimitation process, you are doing nothing but asserting your constitutional right. This is the right that the MDC and Monzora took to the Constitutional Court. This is also the right that Chidawa, the other client I was representing, took to the Constitutional Court. You may be complaining, for example, in the Chidawa situation, his position was, we have heard and we've seen a delimitation report, but I don't believe that that delimitation report is coming from the Zimbabwe Electoral Commission. That was the point. We have read it a lot. We are told that the commission is not operating properly, some commissioners are not there, and that I fear, that was his fear. He feared that this document, which was going to be used and the document for the country, was actually a product of an individual or a few individuals or persons that were not the organs of state responsible for producing those reports. Is that not a fair point? That is coming from section 67. I have the right to a free, fair, and regular election. So because of that right that I have, I'm asking the court to intervene. All we wanted was a declaration. Is ZEC the one responsible for this report? That was thrown out. We are still waiting for the reasons for judgment. So as we discussed, the Constitutional Court has not yet written a judgment on why they dismissed that application. Now, one question you might want to ask is whether, in fact, our Constitution permits the courts to do so, to give their judgments first and reasons later. Because this is what happened in public answer. We dismiss you up. They didn't even give a hint of what those reasons are. So if you wanted them, you ought to have followed in court. You would speculate from the questions that they were asking, where they were going. But we all as lawyers know that court can be questioned heavily in court and still find a judgment in your favor if the court is seeking. But in that case, the court simply said, no, we are dismissing this application. Of course, after hours and hours of haggling in the full court, and our reasons will come later. And I think that was sometime in May or June, I'm not sure when, last year. And up to now, we still do not have the reasons that are there. So as we speak, it's about 12 months from that dismissal, but the court has not. It is very possible when you talk about constitutionalism, because that's about, I'm sure they understand constitutionalism and so on. They would have to find out whether there is a basis for such a situation where a court arbitrarily makes a decision and then finds good reasons to try and support the arbitrariness. That is what reasons is to ensure that you guard against arbitrariness. You can even give a summary of your reasons and say, I'll give them, but at least outline them. In our case in Zimbabwe, currently the practice of the Constitutional Court is that it does not even outline. My lawyers call them ex-tempo judgment, where at least the judge says out certain things. And these are the reasons. I'll put my thoughts in more organized form later. So the Chidawa one was thrown out, but the point was fine, which is, if the report is issued by the delimitation is by ZEC, then it must be by ZEC. Then, in the MDC matter, the Monzora MDC matter, this one was very clearly to deal with a number of issues that dealt with the content of the delimitation report. There were so many obvious errors, so many glaring provisions that appeared to have been clearly contrary to the Constitution. And they wanted that delimitation report more or less set aside on the basis that one of the provisions given which were outlined was this issue that says that there must be equal numbers in constituencies. And that these equal numbers in constituencies can be a variation of 20% up or 20% down. There is no doubt that the ZEC report, and I can say so, I think I'm allowed, that there's no doubt that they went against, they clearly didn't interpret the Constitution properly regarding that 20% variation. There was this gap here, 40%. I think if you get the lowest numbers, I think my constituencies could have 22,000 voters in a constituency. That's what I still remember. And then you can get from my constituency, 35 or 36,000. I think that's something like that. So there's a variation between my constituencies. I end up to about over 10,000. That is not the intention of the Constitution, no matter how you want to read it. It's not the intention of the Constitution. So the FDC challenge was very clear. It pointed out these glaring positions, and its position was we do not have a delimitation report that is constitutional. In other words, a declaration that this report is unconstitutional. So if the report was unconstitutional, certainly there would have had to be remedies to deal with that. Unfortunately, there are some people who looked at that challenge as one wanting to delay the election. In other words, there are so many Zimbabweans who would want an election anytime. They don't look at the content of the election. They don't care about what. It's just an election anytime. So I will belong in the civil society. I put out there. It was always our headache. Is an election anything called an election? Or an election is an election when it meets the substance of what should be an election? It's a very fair question. That challenge by the MDC was about the quality of an election. It was about what our constitution envisages to be an election. It was about section 155 of the constitution. And what they were going to the Constitutional Court to say was, look, we do not have a delimitation report that satisfies the provisions of the Constitution. So we are going to have an election right from the start that is contrary to section 155. Very fair point. But that's a very fair point. Then it went to the Constitutional Court. The Constitutional Court was not interested in it. I think that's my thinking. They were not interested. I'm not sure what they want and what things interest them. You can actually appear before the matter is served and so and so forth. I think they've been good shape. But not interested. These are judges, not interested. Because the only advantage you have as professor, no advantage here. So I appear in the court every time, but I think I go. So I can say here that, look, you must be interested in some issues that are key. You are faced with two arguments. The first one says, look, I want to be satisfied that this report comes from ZEC because the whole public is replete with allegations that in fact this report may not actually be the product of a constitutional body that we were set up. It's a very fair thing and a very fair cry from Zimbabwe. We want to go to the election, but let this become, and not just for that, but for the future. Then again, another issue says, look, this report, on the face of it, does not appear to satisfy the requirements of the Constitution, and we run the risk that we will have an election that is contrary to everything that the Constitution stands for. The Constitutional Court was not interested. And what did they do? Here is a question that was posed at the beginning of the hearing. I will read it. So, Tatangata, we have introduced ourselves and so on. So the presiding judge, who was the Chief Justice, then tells us what questions we have to address. I think courts must be limited in that regard. I wanted that active, I want you to answer this question. So that's what we asked you. Courts must not be litigators. I was in litigation. They must be there. They listen to the argument and make the judgment on the best. So they ask the question. Up to now, I'm waiting for this judgment to see what I answer. Say they may fail to answer it. Says number one, is there a cause of action properly pleaded on the issues raised by the application? This was in the MDC. Is there a cause of action properly pleaded on the issues raised by the application? Then number two, what is the basis of the locus standi? Forget, answer those two questions. So I think we struggled. I'm not sure how many hours to answer my questions in the constitutional code. Abamuri ahead of an election which has to be free, fair, in terms of 155. After that, we'll consider. We'll have a few minutes, just a few minutes. Then they came back to say that the application was dismissed and that their reasons were false. So they will tell us a year later what their answers to these questions are. If you want a situation where a court can be unaccountable, that is one such situation. Reason and make a point there, I think that make a point there. If you have a constitution in place, you have principles, you have everything, you must worry about how the courts interpret that constitution. And the weakness of Zimbabwe is that they don't seem to be interested in making the judiciary accountable. It's one thing to say that the judiciary must be independent. But if people see that the judiciary is not independent and do nothing about it, if they go to the courts and see that judgments are not being rendered in accordance with the dreams in the Constitution and nothing happens, you want another generation of people to come down here and start an advocacy that also makes the judiciary accountable. Because any failure in electoral litigation has to do with the quality of the adjudication. Murubanza, national electoral litigation. Because we are electoral adjudication. Litigation, the E, it means activists go to court, come up with causes of action, they hire brilliant lawyers, they do all they even have imaginative and creative litigants, like what you had in these two cases. You can have all that, but it will fall into nothing if on the other end, people who will sit there and tell you that can't happen, that can't happen, that can't happen. And I think it's going to happen. I've seen my list of cases where I think Dr. Sabora is going to be dealing with those that deal with nomination codes. Include Downa Jeki Panapa, Anna Kesi again, Nagasugwere, Anna Steri. I think she. Ukamomora no go Nagasugwere. I don't know what. And so Annie, Zagan of court and so on. If you read Bazara, Bazara, Joe Marquez, and I was on my exam, you know, Nagasugwere. Those are Kumbaswan and so on. You gotta go to the exam, my chairman on the time, but I don't know where masters were. Taurez on a square. Those are the go to the Taurez on a square. Don't case your master. I didn't take your education. So I was a court, but I don't know my son doesn't put it on. But Taurez on a square. Is that clear? So these are now issues. But the point I'm making here, I think you can see that I'm trying to be very emotional about it. I've made the point, I think, you have a good constitution in place. You must worry about how that constitution is implemented. If you have litigation, you must worry about how courts go about the business of interpretation, so that you have the best litigation issues brought before the court. The reason why Zimbabwe is not up there in terms of its jurisprudence is because the courts are failing us in that regard. So you see, in South African cases. In the South African scenario, cases are brought before the courts, very good cases. And I think the judges do justice to those cases. Then you have a jurisprudence. Here, my case is very correct. But it is the jurisprudence coming out of the court which should warrant. So if there's going to be any constitutional reform, we are going to put in place number one, that a court will not be allowed to give an order without reason. Reasons first, order second. So now you're saying, I see common sense. Just over my reasons, at that point. You would historically, if you are the highest court, you could be allowed if it is an emergency matter and so on. But there must be a limit to those kind of cases. And I don't think a constitution that says that anti-constitutionalism is about limiting abuse of power. And power can be abused, not just by a president, but abuse all them other actors without accountability. That thing must be in the constitution. And we'll have exceptional situations, but if I had my way, I would not even have a constitution. Can I only quote one more thing? I want to argue. You want to tell me? You have my reasons. You might text him one. But you know, I've dismissed your application, the reasons to fall. And then the reasons will come after 2 years. I don't think that is fair for that to be. So that provision will have to be. Then number 2, we are also going to impose a time limit. Because in my case, just some constitution. Judicial ethics, 3 months, then 6, but they don't follow that. One is our constitution when you are judicial. Constitution. So no my points are, I think I went but I think I've made my points about the electoral litigation. If I were to have my way, litigation and adjudication must always move side by side. And those 2 examples show me that a good constitution can go to the dogs if the judiciary does not give it the due respect that it deserves. Thank you very much.
Thank you so much, Professor Matuku, for that outstanding outline. And just to piggyback on the issue around time limits that you mentioned, I am going to give a time limit to your co-presenter, Mr. Mana, especially because he's going to be agreeing. He's come forward. Giving time limits to the chair of the organization that is hosting.
Okay, thank you very much. I want to thank Professor Matuku for running and for laying the foundation, as well as even to finish. If it was a building, he finished it. I am grateful to ERC director for organizing, and I'm also happy to acknowledge the presence of all of you, and also to welcome President Douglas Monzon, as well as also President Professor Matuku. There. Well, thank you very much. It's very simple that I'm coming after a professor. I won't say much. Delimitation, absolute versus substantial compliance and impact on elections. I think for some of us who do not know what substantial compliance is, or what they have written there is absolute compliance. I think when we talk about substantial compliance, we are talking about something that does not exactly follow or obey the provisions, but something that is almost getting there. It's like if it is a bottle of water, maybe it's not full, but it's somewhere there, it's almost full. So it's substantial simply means you have tried to comply to the exact letter, but you have missed a little bit. But then the court will say, well, we take it that you have complied, because there is substantial, not exact compliance. So the question here is whether, when we talk about delimitation, there can be something close to the provisions, strict provisions of the Constitution, or exactly the compliance. So absolute compliance there is exact compliance, to say you must exactly comply with the requirement, rather than to try to comply by coming close to what is required. So the question there is to say, do we go by absolute or exact compliance in delimitation, or we can go by something that is close to the letter, but not quite? I hope, Mukomarege, you have understood the issue there. So then the question then goes to what then happens, the impact on elections, either exact compliance or substantial compliance. What does that do to elections? What impact does that have to the elections? And I believe that Professor Matuku was talking to us about the principles laid out in the Constitution. And one of the principles that stand out in the Constitution, as he explained to us, is the principle of equality of votes. And like he was saying, yes, We know that equality of votes, most of us will just say, well, it's, each person must have a vote. Each person must have a vote. That equal vote means one man, one vote. Of course, that is the general or basic understanding of equality of votes. But we went further than that with Professor Matuku in the case of MDC and Senator then Douglas Monzora, to say that equality of votes is also in delimitation. Was delimitation in terms of section 161 of the Constitution of Zimbabwe. Wards and constituencies must be, as far as possible, equal in number to each other in terms of the registered voters there. So in other words, if a vote is South, if there's such a constituency, it must have an equal number as we have in, say, Buhera North, so that there is equal representation in parliament. You cannot have a member of parliament representing 1 million people in parliament and another member of parliament representing 2,000 people in parliament. There's no equality, because it's a constitutional representative democracy where there is equality of representation also in parliament. It also becomes equality not only in representation but also in resource sharing, resource mobilization, and resource distribution. For example, if one who comes from a constituency with 50,000 people and another from a constituency with 5,000 people, and they both receive $50,000 as constituency development fund, there is no longer any form of equality. And also in terms of the delimitation process, there is equality in the sense that the people within a constituency must be under the same interest. For example, if we are in Harare Central, we cannot be put in the same constituency as somebody in Mureva North. They are talking about cattle, they are talking about deep tanks, they are talking about this, and here we are talking about sewage and things like that. So at the end of the day, the representative must talk about representative issues that represent the people within that same constituency. So the equality there is also in terms of being in the same constituency as somebody who falls under the same needs as you do. Those are the things that are considered in terms of how to delimit whatever. So in terms of the constitution, if there's any variance, of course the lawmakers knew that you cannot have exactly the same number to say if constituency A has got 10,000, constituency B has got 10,000, and so forth and so forth. So they knew that it's almost impossible to do that because of geographical reasons. So they said if there's any variation or variance between constituencies, it should be at least 20%. Now, in terms of ZEC's report, there were differences or variances of about 50% as between other constituencies. For example, President Monzora and the MTC then did a table where they would show that, okay, Budiro North, for example, had so many registered voters. If you compare Budiro North to, say, Bulawayo Central, the variance between Budiro North and Bulawayo Central was 49%. If you take Budiro South and Bulawayo Central constituency, the variance was 40%. If you take Harare East and Bulawayo Central, the variance was 50%. And that will do violence to the principle that Professor spoke about of equality of votes in terms of Section 155 of the Constitution of Zimbabwe. It will also do violence to Section 67 of the Constitution, which talks about right to free and fair elections. Freedom and fairness of elections is also between constituencies and what? You cannot be in Mrewa and you are electing somebody there and somebody is electing someone there and you are differently treated. That would still be an unfair election. So that is what would impact on the elections. Before the Constitutional Court, and we were there with Professor Matuku, the question was, okay, Douglas Monzora is not a candidate as an MP. How does he get affected by the variance between constituencies and what? How does he get affected? Those were, I wouldn't want to characterize those things, but I think Professor has said they were asking questions whose answers they don't know. That's why they're stuck with the judgment as we speak today. But a president of a political party has an interest in what happens in every constituency. And even Monozenos Boram Sabo no kawiva kupiko, kuba constituency koko. And you know very well that the president must package the campaign information depending on which constituency is going to. If you're going to a place where they grow timber, you talk about timber. If you go to a place where they grow cattle, you talk about cattle. So your messages are couched in relation to where you want to go. Mobilization of resources and things like that are counted in terms of, or rather are done in terms of where you want to be. So at the end of the day, if there's a lot of gerrymandering there, if there's a lot of this and that, it affects a presidential candidate. The question was asked, what local standard do you have? What local standard do you have? Local standard is simply a right of a litigant to go before a court to get a remedy. Like the case that Professor Matuk was handling of a citizen, concerned citizen who wants to say, I am somebody who's going to elect, and I want to elect in a free and fair environment, and my right is that I must know that this delimitation report is indeed a valid report upon which the right to elect can be exercised. And I want to say, if there is a delimitation report that is invalid, it basically means there's no valid election, because an election must be based upon a valid delimitation report. Of course, the fear was Mozora is afraid of elections, but we know what the elections caused after Mozora was afraid of those elections. And those that were courageous enough are now living with the route. But at the end of the day, yes, an election can be impacted upon. I want to say Section 2 of the Constitution of Zimbabwe talks about the supremacy of the Constitution. And I think our Constitutional Code has already said there must be strict compliance with the provision of the Constitution. So if you want to ask me a question about whether there can be absolute or substantial compliance with a provision of the Constitution, I would say it has to be exact compliance as opposed to substantial compliance. So these are they. I said my reasons would follow. These are they. That's what the judges always say. When they give an actual decision, they just say, we dismiss you. And then when they come later, after 5 years, they'll say, in our hearing, we dismissed the application. We said our reasons were to follow. These are they. So these are they. Thank you.
Thank you so much, Mr. Mann. Now, I'm a bit scared of calling the next speaker, because I can be told that we are speaking as a panel and we have agreed this, that. That's the problem of chairing panels with presidents who think they have a lot of power and can change everything. Please do not change this order. Okay. Oh, thank you. Fortunately for you, what you have agreed on is what I had decided. So to respond to the presentations that have been made by the two gentlemen, I'll now call upon first Mr. Arnold Tsuga to share his input, and then the litigant will have final say.
Thank you very much, Mr. Moderator. Very capable and able moderator who is making everyone feel very comfortable. Then let me also start by thanking the organizers. I think it's an important meeting. We are learning a lot and it's quite overdue. Then I also want to defer to the Dean of the Law School who is here and the leadership he has been providing to produce lawyers for the country, and I'm hoping that with this type of meeting, there could be a lot of public lawyering that we see in our community, because we need it. I know that there's a lot of criticism sometimes that we have too many lawyers, and therefore maybe lawyers have become part of the problem, but I actually think that we still are part of the solution as well, because when you live in a repressive environment, you will find that there's a bunch of lawyers who are aiding. Dr. Magesa always used to call them enablers. I think he used the phrase enablers. And then there will also be a bunch of lawyers who are really battling hard. I see some of them here. I see Tinashe from Zimbabwe Lawyers for Human Rights, who really work their butts out to try and push back on repression. And then let me also thank Dr. Matuku for your kind words. You know, we all defer to Dr. Matuku when I was still with Zimbabwe Lawyers for Human Rights and in our formative stages. He gave us a lot of advice and a lot of courage, but also a lot of skills in capacity building that made Zimbabwe Lawyers for Human Rights what it is today. And then my brother, Mkomataki, yes, we also came a long way, and he played a big role in the national constitutional movement as well before he joined politics. And he has always tried to be a constitutionalist. And the problem with politics sometimes is that by sticking to principles, you sometimes lose the popular support. And yet, if you ask what is at the core of our problems as a country, you might find that the question of having a good constitution that Dr. Maduk spoke about, and not having good constitutional practices, so that there's a marriage between a good constitution and good constitutional practices, so that we equal the principle of constitutionalism. That is a missing link, and until we as a society begin to be wired in a way, those we love, those we hate, those we give responsibility, we measure them on the basis of their performance with regard to our founding document, which is basically the valid document, our constitution. And so they raised a lot of very interesting issues. And I think the question of constitutionalism, and in particular the clauses in our constitution that are so important for us to have credible elections, free, fair elections that allow for our country to have social cohesion. Because we are suffering from discohesion as a society. The inability of Zimbabweans to be able to resolve even small problems has placed our country at a huge disadvantage when you look at the performance of our country in the context of the natural resources, the wealth that the country has, but its inability to unlock the potential for all of us, all our citizens, to be able to live with dignity and to actually be absorbed into meaningful economic activity. I think that at the center of that is the failure of all of us to have cohesion. But what could be the instruments that can make us a bit see things with better cohesion in our diversity, in our difference? We don't have to love each other, to like each other. We can be very different, but there should be minimum things that bind us as a society. And my view is that the constitutional principles, the constitution itself, given that it was voted for by over 93%, it means there's an aggregate acceptance on the part of Zimbabweans that with its imperfections, but it is the document that must define the relationship between those who govern and those who are governed. So I totally agree with Dr. Matuk's view there. So there are a number of constitutional provisions that have been highlighted, which we all need to do a takeaway. The question of Section 67, political rights, the need for whoever is given the authority to administer elections in Zimbabwe to ensure that elections can produce an outcome that is deemed to be free, fair, and with sufficient regularity, so that those who are in power have the legitimacy in terms of our constitution. And that people must also make political choices freely. That's Section 67. And the cases, both cases deal with that aspect. Then the principles of the electoral system, I thought, Dr. Maduko, that was very good to introduce that at the level of appreciation for all stakeholders involved in elections, either as civil society, as political parties, as administrators of the elections, as courts, as individual voters, it's important to have those principles central in terms of how we conduct ourselves, but how we also judge processes. So the principles, in section 155(1), peaceful, free, and fair. The question of conducted by secret ballot based on universal adult suffrage and equality of the votes, and then free from violence and other electoral malpractices. These cases that they spoke to deal with aspects of those, some of them directly, some indirectly. Some of them is through deductive logic, when you say what is a free and fair election. Can an election be free and fair when what the trust Manda says, that you can have constituencies that are so large compared to others, to the point that the members of parliament, the councillors in those areas are actually having a larger population to represent than the others. So this delimitation report seems to have been done in a way that breached that constitutional principle of electoral law, of the election itself, but also the principle of delimitation. And there is the issue of jurisdiction that was raised by colleagues in terms of whether there was locus standi or not, as well as whether there was a cause of action or not. And when you look at the constitutional provision that they referred us to, you will find that the cause of action is basically based on the fact that everyone in Zimbabwe, according to Section 68, is entitled to free, fair, and regular elections, essentially political participation without any inhibition. Then when you look at the Section 85, I don't think anyone spoke about that, which talks about the enforcement of fundamental human rights and freedoms. The Constitution also says that any of the following persons, namely any person acting in their own interest, any person acting on behalf of another person who cannot act for themselves, any person acting as a member or in the interests of a group or class of persons, any person acting in the public interest, and any association acting in the interest of its members is entitled to approach a court alleging that fundamental rights or freedoms enshrined in the Constitution, especially the Bill of Rights, has been or is being or is likely going to be infringed. And then the court may grant an appropriate relief. So when the provisions of the Constitution are so clear, Dr. Maduk spoke about Section 67, is it the political rights that my right to free and fair and regular election has been affected because of the way in which this election is being managed. That's a Bill of Rights clause. And the specific provisions that open up the courts to be obliged to hear the case and to grant remedies upon evidence are very clear in Section 85. So those questions that Dr. Maduk and Manda spoke to as questions that were asked by the courts on the entry, they look too elementary as questions. And it may explain why the frustration is there on the part of the lawyers, but it may also explain why there's been a delay in the giving of reasons for judgment, because you have to find a way to navigate as a court out of these very specific provisions provided for in the Constitution, which I think is very uncomfortable to do. But then I would understand that maybe the court at that point, with the pressure of the election date approaching, and the fact that delimitation appeared, I think, in the minds of the courts and many people to be a deal breaker, an election breaker, that if the order that was being sought is granted, what is the implication on elections? And I think that's where I saw one of the cases that ERC cited, where Bamu, the lawyer from Zimbabwe, Mchale Ahmed Associates, was asking to be an amicus, a friend of the court, which is also provided for in the Constitution, to say that one of the remedies that was being sought, I think in the case of Senator Douglas Monzora's application of postponing the elections, he was thinking that that's not the only remedy that can be made available if the delimitation report was to be deemed or was to be determined not to have been properly attained. So he then introduced in his case that the remedy is actually provided for specifically in the Constitution, which says that the delimitation has to be done every 10 years, every 10 years, and that it can only be done following a census. And that if there are delays, if there had been a delay, which is I think what was operating in the minds of the court, it would have meant that this delimitation report could not have been used in the 2023 elections. And what was the implication of that? So the implication of that would have been that the election would be conducted on the basis of the 2007 and 2008 delimitation report. So that was outmoded, and it, on the face of it, breached the principle of equality of the vote. In that, I think the example which always got given when I was still active in the sector was that the smallest constituency on that delimitation report of 2008, 2007-2008 would have been Gutu, I think with 15,000 voters. And then the largest constituency then was Harare South with about 78,000 voters. So it then means that if you put 15 to 75, one vote in Gutu would be equivalent to about 4 or 5 votes in Harare South. And that would obviously introduce a big constitutional challenge also around whether that achieves the principle of universality and equality of the vote. So I think the courts found that the country was in a very difficult moment ahead of elections, and I think mindful of the consequences of elections that are held in an environment of severe, demonstrable, and potentially justifiable disagreements, that maybe the country could have been in a conflict or a conflictual outcome. So, and conflictual in terms of political violence or political disagreements, but not including the election outcomes, because I think the political parties could, or people who felt that that delimitation report introduced such gross unfairness and breach of the principle of equality of the vote that it could have then triggered more litigation. So maybe, I'm simply supposing that maybe that's the reason why the courts came up with this strange position of giving a decision but without giving reasons for that judgment. Which then takes me to another issue that this case brings about in terms of the institutional framework that the country needs to be able to run elections with integrity. I'll talk about ZEC later, but this issue of the way in which the courts handled the litigation, I think Barbara was clear from the beginning that there were over 100 cases, and that the cases took place involving the pre, during, and after elections, and that it was the most litigious election. But that is not a characteristic that is unique to Zimbabwe. It's a characteristic that is now beginning to reflect across the whole of the continent. So in a way, the courts have become an election institution, if I can put it that way. Judiciary has now become an election institution in Africa. And it raises a number of problems because the principle of independence, impartiality, and accountability of the judiciary, the fact that the judiciary is a branch of government that comes into being not as a result of an election process. They're not deployed into office by voters. They are chosen through a method that does not involve the public. And so their only currency is really to be seen in practice and even in perception as independent, as impartial, as accountable. And when that perception begins to be interfered with, then it also erodes public confidence in the judiciary as an institution. So I think elections by their nature are a phenomenon that's new to the judiciary. It could be old, but the volumes are introducing a new challenge around how judiciaries can maintain independence, how judiciaries can be seen to be maintaining independence, impartiality, but in particular accountability. The question of giving judgments without reasons is a breach of judicial accountability. Because judicial accountability is the reverse side of judicial independence. Judicial independence is given because the public, the Zimbabweans, when they say judicial authority is vested in the courts and in judges, is vested by the people, on behalf of the people, and therefore it's a public interest organization, it's a public interest entity. And the only way in which the public can remain confident about its performance is if it conducts its affairs in an environment that is seen manifestly as independent, impartial, and accountable. So the question of accountability in terms of the technical accountability of the judiciary, to say you've had the case, you've conducted it in a way where you've demanded lawyers to conduct the proceedings in a way that does not seem to have given us the right opportunity to be heard. Because part of the right to fair trial includes the right to be heard and to hear the other side before you make a decision. But if you feel that you're being constrained in the way in which you're presenting your case, in the way in which you are approaching the case to persuade the court to come to the same decision as you are asking for, you could say that the right to a fair trial is also now being interfered with. So I think there's a fundamental question around accountability. Let me just, I've seen I'm told that the time is up, but let me just talk about the other issue that this case raises. I think the question of independence of ZEC, it also comes up in this matter, because I think in one of the documents that I saw, there were, I think Dr. Maduk's case, you alleged, or your client alleged, that there had been commissioners who wrote a petition or some document to the executive, dissociating themselves from the delimitation report and saying that it's not done by the body corporate, because the ZEC has to operate as a body corporate. So if those assertions are true, it raises the question of whether the delimitation report is a ZEC report. But because the president then went ahead to submit it to Parliament, and Parliament was now considering that delimitation report, which was being deemed to be not a ZEC report, the issue now is who had the honors? Because I think the question of honors, maybe that's where the judiciary is still keeping its reasons for judgment. But they'll be saying, if those commissioners indeed wrote that petition, are they not the ones who were supposed to be appearing in court to say, I'm a ZEC commissioner, I was not involved, this delimitation report is not ours, or the meeting that we held on such a date where this delimitation report was considered did not come up with that report. So I think that's where the court may be waiting to say that aspect could not have been alleged in the papers. But I think the moment a litigant shows that there's a petition that has been signed by 7 of the commissioners and only 2 did not sign, dissociating themselves, I think that's enough discharge, or shifting at least of the honors from the applicant to ZEC and to Parliament to show why that petition should be disregarded. If in the case that petition had not been filed or alleged, then I would say maybe the courts could have been looking at who has got the honors here. So let me, then the question of civil society in end. I think Dr. Maduk challenged us as civil society to say that there's been quite some significant developments that have happened in the pre-election phase that would have required a more robust engagement with the system. Because I think the political parties themselves who looked at the delimitation report and saw tactical opportunities rather than simply looking at it from the lens of legality and constitutionality. They saw tactical advantages and felt reassured that despite the fact that the delimitation report had not been done properly, they would still score. So I think they were looking at the end result as opposed to ensuring that the process. So people like Dr. Lewanika will say that the process has to be certain, but the outcome has to be uncertain in elections. So, and I think the preponderance of being asphyxiated to the fact that we will get the result, notwithstanding the process, makes some of the political parties decide to go for elections. Dr. Madhu says people like elections, where they give you a certain hope. It's a mirage. You see your success, you see yourself in office, you see yourself controlling the state apparatus, and as a result, you don't then focus on the principle of legality and constitutionality. So I think that's what I'll say, and thank you very much indeed.
Thank you so much, Chairman Soga. President Mozart.
Thank you very much, Dr. Lewanika. It's one of the most fulfilling moments of my life, where you see a person who has achieved a lot, and you played a part in protecting them. Dr. Lewanika was expelled from school, and they looked for a lawyer, and I happened to have been the lawyer. So I do share, in some way, his success. All protocol observed, the Dean of the Faculty of Law, leaders of civil society who are here, members, leaders of political parties. I see my sister Linda is there. My co-panelists, brothers in crime. We have been together for a long, long time. And Mkoma Arnold may have forgotten it. He was a soccer star of repute and used to star for the University of Zimbabwe team. But the law faculty had a team which was called Red Stars. And these elder brothers would not allow us to play for Red Stars. So under the influence of other people, decided to form a rebel team. And we called it Contra Bonus Morris. Ladies and gentlemen, sometimes I feel that you should tell Zimbabweans that I told you so.
Okay.
This delimitation case, ladies and gentlemen, was meant to achieve three things. Number one, to have the delimitation report nullified. Number two, to urge, to get ZEC to redo, to correct its mistakes. Number three, to then ask the state president to proclaim election upon receipt of a correct delimitation report. So, civil society, well, some civil society to be fair, political parties, journalists, all colluded to misrepresent this case. And it was, Monzora is afraid of elections, and that is why he's taking the government to court. Somebody even suggested that I was doing that under the instigation of President Mnangagwa. And I tried to explain to a deaf nation that in 1995, I had tried to stop the presidential election on the basis that the Electoral Act was not democratic. I lost in the Supreme Court. And in 1997, I had taken the government to court over the constitutionality of the Political Parties Finances Act. And this time we got our act right and we won. And when you see the political parties fighting about the political parties fund, it came as a result of that. And then fast forward in 2023, I take the ZEC to court over an unfair delimitation. And then they say, you are afraid of election. And there was so much collusion, so much misrepresentation of the case, that we committed a grave injustice in this country, all of us. Ladies and gentlemen, I will just let you into some of the things that you don't see that were happening in this case. The first one was that after I filed the case, Chief Justice went to open a court in April. He was overheard saying, because we also have intelligence, you know. He was overheard saying that Monzora's case is good, but the problem is that Monzora is bringing this case after ZANU-PF has had its primaries. That is a problem. So I was told about this, you know. And then 3 days before the hearing of the case, I again received intelligence report that 5 out of 7 judges were inclined to grant judgment, and that there were efforts to change that. And then on the date of the hearing, the Chief Justice started asking, what is Monzora's locus standi? What is his right of coming to court? Of course, I was seated and being ably represented, but I almost felt like leaping up and answer to him. I am a constitution maker. I am a president of a political party. I want to be president of Zimbabwe. I want to form a government. And I will form a government, a cabinet from MPs. And therefore, of course, I am interested in a fair delimitation. So they were overly technical. They even asked, I think, the issue about whether there is a proper case pleaded and so on. And here is what we had said. In terms of section 166, a delimitation must follow a population census. That means that you must have results of the population census so that you can delimit. And Zimbabwe had a population census in 2002, April, but the results of the census were not yet out. And therefore, we did not know how many people were in Uzumba Maraba Pfungwe, how many people were in Nyanga, how many people were in Cholocho. So we were fighting in the dark. I even went on to say, as a presidential candidate, I want to plot my campaign route. And you plot your campaign route based, among other things, on population density. So we had no information about population at all. And ZEC had said that this was unnecessary. We consider only the registered voters and so on and so forth, which was totally not correct. The other objection which we had was that the law says that constituencies must have equal number of registered voters. But in the case that there is variation, it must not exceed 20%. And we were able to demonstrate by a table that these constituencies at 50%, 40%, and so on. In fact, 199 out of 210 constituencies were wrongly delimited. We were able to demonstrate that. We were also able to show that looking at the coordinates that ZEC had put in the delimitation report, where the constituency, for example, was located in a land after Cape Town, in the Atlantic Ocean, somewhere there. That's where the coordinates would take you. We were able to demonstrate that in Bulawayo, for example, there were certain areas which were not in any ward or in any constituency. And we were able, by way of satellite, to tell that 3,000 households were affected. Now, if we say 3,000 times an average of 5 voters per household, we are talking about 15,000 people. We were able to demonstrate that. Now, on the day of the hearing, the judges, after talking all this thing about locus standi and so on, they asked for a 20-minute break. And I think a professor had forgotten. They asked for a 20-minute break, but they took more than 20 minutes. And they took about 2 hours. We don't know what they were doing, but what we do know from our intelligence is that a national hero was being buried on that day. And the convoy of the president and also the vice president was traveling from Heroes Acre to State House during the break. And that the judges only came after the president had been safely put into State House. So you can put 2 and 2 together, that, and I made a remark, and I'm allowed to do that because I am a politician. It was a political judgment. The Chief Justice simply said, "We refuse to hear you. We refuse to hear you." That's what he said. So I have come to court, I want justice, and they refuse to hear me. So I made a few predictions after the judges made that infamous decision. And my prediction was the election will be disputed, number 1. Number 2, the country will be internationally isolated. Number 3, that the opposition was going to disintegrate immediately after the election. This delimitation report has more consequences than you see. And it came to pass. You will know, ladies and gentlemen, that Tony Chidao, who was represented by Advocate Madugu, is a ZANU-PF Youth League member who was so unhappy about delimitation, went to court, and he was abducted. He was abducted by state institutions, state officers. And the members of the Ministry of Justice were also abducted to such an extent that the Minister of Justice was afraid of his life, afraid for his life, sorry, on the basis that he had clear opinions about delimitation. He was not in agreement. And in Parliament, I had sat in the ad hoc committee that looked at the delimitation. It was a multi-party committee. And everyone, we were able to demonstrate that this report was no good. We called the Justice Chigumba, who is an old friend of mine. We were in school together in Goromonzi. I think she was in Form 4 when I was in Form 5. Quite outstanding lady, and so on. So we called her to appear before the ad hoc committee. And before she came in, I addressed the ad hoc committee that we are not going to harass her, that we are going to be respectful, and so on. And then she came, and I was the first person to ask her a question. Justice Chigumba, why is your report not signed by any other commissioner? It's only signed by you and I think Commissioner Kiwa, the deputy. Others had not signed. The previous delimitation report had been signed by all the commissioners. She was, I think, she struggled to answer that. And of course, there were a lot of things that happened. Threats were made to myself, to my party, and so on. And you know that 87 members of the MDC who wanted to be candidates for MP were disqualified, unfairly disqualified on the basis that they not made available means with which to pay. So there were so many consequences. But Zimbabwe finds itself now in a situation where this delimitation is going to govern the 2028 elections. You see, This delimitation is for 10 years. It is going to govern 2 elections. So already we are going into another election with this delimitation. And therefore we must fight this delimitation. And we must fight it together now. Yes, you may have a person you don't like. Yes, you may have a person you object about the way they do their politics. It is to be expected in a democracy. But take a minute to listen, please. Let's listen to each other. The conversation, political conversation in Zimbabwe is a typical conversation of the deaf. People don't listen to one another. And my young brother, Jeremiah, came. We know who brought him. Jeremiah came to be a friend of the court. Common note is correct. It is allowed to be a friend of the court, to be amicus. But Jeremiah was saying worse things than I was asking for. Jeremiah was asking for the election to be delayed by a month. I was not asking for the election to be delayed. I was asking for the delimitation report to be redone. And of course, that was lost. So, ladies and gentlemen, I want to thank all those who have seen the light and see that this delimitation is no good, that we must fight together. I want to share a story with you. One day, I was summoned by Chief Justice Chinchigao Siku and the senior judges of the Constitutional Court during constitution making process. And myself and Honorable Mangwana, we were called. And we were taken to lunch for the first time. We were taken to lunch by judges at Emmanuel Restaurant. And at that time, we were drafting the Constitution. And we were already debating about the Constitutional Court. And I was very, very strong about it, that this country must have a Constitutional Court which is separate from the Supreme Court. So when we got to the lunch, you know, I'm a very polite man, you know. And so when we got to lunch, I thanked the judges for the lunch, and they started talking, trying to influence us. There is no need of a constitutional court. It is totally unnecessary. You guys are copying Kenya, you are copying South Africa, but Zimbabwe is a sovereign country. That was Chief Chinchigao Siku. So Honorable Mangwana was the one answering them. And I kept my peace, I kept so quiet, because I was enjoying the food also. And then at the end, the Justice Makarao says, but there is a man who has not spoken, and it's rare for this man to do that. So, Honorable Monzora, can you give a vote of thanks? So I stood, I thanked them for the food, and then I said, there shall be a constitutional court in Zimbabwe. And so it was. So it is there. So this delimitation, we are going to fight it tooth, claw, and nail. Maybe we didn't do enough advocacy. Maybe we didn't explain to each other well enough, but we need to fight it. Now, as I close, Dr. Maduku challenged me to say, I must show you the good things that we did in the Constitution. And now, in anticipation of major litigation, there is a section that I want you to be aware of. There is talk about the third term. And the president wants to be given a third term. And the lawyers now are now debating, and they are saying, no, instead of giving a third term, let's now lengthen the term of office of the president. So instead of 5 years, it's going to be 10 years, 7 years. So it's 5 years will end in 2028, the other 2 years in 2030. That is why you have that slogan now, 2030 day leadership. Unfortunately, some members of parliament are agreeing to this because they want to stay in parliament for as long as possible. So you have a major issue that is coming in this country. And we have an answer to that. We have an answer to that Professor Maduku. and we have section 328 that we crafted. And when we were crafting this section, I felt that it was going to be important, so I kept the manuscript. I still have the longhand written part of that section. And this section says, you cannot extend a term limit, but should you want to extend a term limit, you go to referendum, right? Should you pass at the referendum, should you achieve a yes at the referendum, and there is an extension of term, that extension shall not benefit the incumbent. You see? So that is one of the smart things that we did, Professor. Ladies and gentlemen, I want to thank you for this opportunity. Thank you very much.
Honorable Monzora, thank you so much for President Monzora, thank you so much for your contribution to the conversation and for turning a lot of these private and secret engagements into African secrets, which we will keep to ourselves. Also, but we will Google Emmanuel Restaurant and see where exactly it is. Mr. God, I now seek your guidance as my elder. What do we do? We are running 30 minutes behind. We are supposed to be coming back from tea right now. What do we do? Thank you for that clear guidance, Mr. God. Colleagues, we are late. What I can do for purposes of just allowing a little bit of conversation. If there is anyone who's got, is there anyone with a burning question for the panel? Burning question. Right, there are none. Okay, so let's break for tea and come back at 11:45 for the next session. And if you've got questions which are not burning for the panel, find them during tea and ask. And they are all accessible. There's a trial. Thank you. Please clap hands for them. To anticipate what Dr. Sabora is going to talk about, a standard has been set, so you have a responsibility to meet it. But he is an academic at the University of Zimbabwe and also does a lot of consultancy work on human rights, democracy, rights and governance issues. With him is, next to him is Tinashe, right? You are the one who was mentioned as doing some admirable work by Arnold Zunga. He has already been introduced. He's a lawyer with the Zimbabwe Lawyers for Human Rights. Next to him, we have Nyasha Machirori from the Zimbabwe Human Rights NGO Forum, right? It says Miss here, but we're Mrs. Yeah, Mrs. Nyasha Machirori from the Zimbabwe Human Rights NGO Forum. And Advocate Sunday has already been referenced as Jackie by Professor Matuko. I think he's the only one who can call you that. To the rest of us, it's Advocate Sunday. She is a legal practitioner, runs her own firm, and in this conversation, we'll be able to walk us through some of the issues around the Sukuwere case. I think that was the expectation that was made. So, ladies and gentlemen, without much ado, however, this panel is going to be a bit different. We've got one main presenter and then three respondents. Our main presenter on this subject is Dr. Sabora. I invite you to lead the conversation.
Thank you very much, Director of Ceremonies, Dr. Lewanika. I would want to say that I acknowledge all the senior invited guests. I will stand by the protocol that has been established before. As Lewanika said, I will call him by his name, not his title. Lewanika said, Sabora James, I'm a lecturer at UZ, so also a consultant in governance here in Zimbabwe. So yeah, there were critical perspectives that were shared by the previous presenters. My lecturer, Prof. Maduku, who is our mentor. You know, these guys were talking about issues
in the 80s, in the 90s, when I was at primary school and secondary school. So I'm lucky also to be part of a generation of people who were mentored by Prof. Matuku in other lectures, also one along at the faculty. But just to highlight key issues that they have said that dovetail with my presentation. So number one, the issue of judicial accountability. That issue is central to a democracy. It's an issue that is central to a sense of justice. It's an issue that is central to human rights. But I feel it's an issue that our Constitution is ignored. So whatever is there in the Constitution, and we know the Constitution, it misses its mark in terms of judicial accountability. Just like the Prophet said, you can have a good Constitution, but if the judges do not come to the party, then the Constitution will go to the dogs. So today's presentation is centered on elections or electoral adjudication. We were given some cases to go through and make our comments. So after going through the cases, what I will do here is I will first of all tell you the findings, the general findings from the cases that we studied, and then we'll go through the cases together with this panel that we have. Number one, we are in a constitutional democracy. Our democracy is based on the Constitution. So it's not based on custom, on culture, or on anything, but on the Constitution. Because we have that democracy, there is no one here who can doubt that elections are the true test of democracy. Some people can say human rights, some people can say justice is the test of democracy, some people can say fairness. But you must admit that elections are central to the form and shape of democracy that exists in a country. So they are critical to the kind of democracy that we chose. Some people have said that this democracy was given to us by the West, it's not our democracy, but this is our Constitution. We had every right to innovate a model of democracy that we like. We had that choice, and we made that choice. So we put those fundamental pillars that shape our democracy and said, this is the democracy that will shape Zimbabwe society. And we agreed in the Constitution. So the democracy in our Constitution is the democracy that we must support. Elections in that Constitution, through electoral law, are the true test of that democracy, because once you have, you can have many things that can undermine elections, you can have many things that can promote democracy in the elections. One of the things that we found from these cases is that electoral adjudication itself can either undermine or promote the kind of democracy that we aspire to. So all these cases reflect electoral adjudication, where they adjudicated correctly, or the courts missed a chance to go deeper, to shape society, to give us a true sense of justice, or a true sense of fairness. Number two, we cannot doubt that electoral disputes are finding themselves in courts more and more. So there's this trajectory whereby a year before the elections, or once the election cycle begins, we have so many cases that spill into the courts, placing the judiciary at the center of the storm. We love the judiciary to decide disputes. That is the hallmark of constitutionalism, is the hallmark of rule of law, and all other notions of democracy. The courts must be at the center of dispute resolution. So we are seeing more and more cases that are being adjudicated upon. So as elections come and go, be prepared for more and more cases that are going to be decided in the courts. Some people have said we are going to have more and more judicialization of elections, of electoral matters. The judiciary is at the center of deciding who goes to vote, who can be voted, who cannot be voted, and who cannot go to vote.
So we have to appreciate that role. These cases, the nature of these cases that we studied, showed us that anything can be adjudicated upon, right? Then number 3, the increasing prominence of the concept of inclusivity. We also checked whether the approaches that our judges are taking is inclusive enough. Are the judges aware of gender inequality? Are judges aware that women face massive barriers in political participation? Are the judges aware that we have socially marginalized groups that needs them to interpret the law in a purposive way, not just the literal way? Are judges aware that law can be gender neutral, but can have massive discriminatory consequences for one gender or for one social class? Do we have a judiciary that is alive to these concepts of inclusivity? I think there was one case actually where the judge said law is law, right? Even if they will pay a blind to the fact that one of the appellants was a woman, or that gender is being put as an issue. Then number 4, electoral contests. I think I said this before, but I'll just repeat it. Electoral contests are encompassing now the whole life cycle of elections. So when I grew up, these cases, you would see them, most of the electoral cases were on the election results, right? People challenging the outcome. It was not fair, I should have won, the numbers, the counting, right? But now, we have seen cases, we have seen electoral cases going as far as the nomination court. The first thing that happens in the electoral cycle is electoral context that is gone to the courts. So the electoral adjudication is now encompassing matters that are found throughout the electoral cycle, pre-election, election, and also post-election. So going forward, all law reform, all constitutional reform, all policy reform, institutional reform, advocacy must focus on the whole life cycle of the electoral process. The next point, there is an increasing awareness by civil society, by the public, that the judiciary can be the agents of exclusion in as much as they can be agents for inclusion. The courts can make or break a society, right? The courts can be exclusionary. They can have a toolkit to just exclude you. You listened to what Honorable Mondora was talking about in terms of the delimitation, right? To just have your case thrown out like that. That's total exclusion. I am a president of a political party. I am interested in the correctness of a delimitation report. And the court says, or you have not convinced us enough, or give judgment later. That is staggering, isn't it? That is staggering. When the courts fail or refuse to properly adjudicate or to properly wear on their adjudication laws, then there's a problem. So the courts can be agents of oppression, they can be agents of exclusion, they can be agents of inclusivity. In terms of exclusion, the judiciary has got a toolkit that can make them hear your case or refuse to hear your case. So in the cases that we focused on, issues such as local standard, we have a traditionally minded constitutional court that grew up, that practiced during the era whereby the test for local standard was substantial interest. So you'd find them trying still to go there despite the clear provisions of what? Of Section 85 and Section 86 of the Constitution, which is very what? Liberal. But we also acknowledge that the courts have come to the party bit by bit to try to embrace the liberal approach to local standard. But if the courts insist on some of these technical issues, they can be agents of exclusion. It means some people will not vote, some people will not be voted into public office. Then, still on those toolkits, they include several instruments. Issue of jurisdiction, issue of wrong procedure, or wrong court, several issues that leave you with a bad taste of justice, or with a bad taste of fairness, to say why have the courts failed to go to the merits of the case in favor of these technical points. So we were checking whether the courts preferred to go to the merits or prefer to go to the technical points in order to determine. So those are the major findings that we made. So we had the opportunity of analyzing 4 cases. I will just go through them in brief, and then my friends who are sitting here will also try to go deeper on those cases. I think the Mangwana versus Kasukuwere case was very national in character, was very interesting. We were waiting to hear whether what the court would say. Would the court give us a jurisprudence that would shape electoral adjudication going forward? So I won't go through the facts, but basically the issue was about residency. Mr. Kasukuwere was out of the country for more than 18 months, and then there were clear provisions in section 23, subsection 3 of the Electoral Act that said the voter who is registered on the voters roll. Basically, that imposed a residency qualification before anyone could be identified as a voter and also could be voted into public office. So we were checking on the treatment of the major issues by the court. I want to hasten to say that it seemed that the case centered on what can be called a minor issue, an evidentiary issue, was Kasukuwere in Zimbabwe for the past 18 months or not, right? But there were many legal issues that arise from that case. So the court said no, he had not given proof. He had not proved that he was in Zimbabwe, right? So the state alleges you were not in Zimbabwe. So the state must prove what it alleges. But the court said no, if the allegation by the state is in the negative, the onus to prove shifts to the what? To the respondent who has everything to himself, he has every document, every kind of evidence to prove that he was in Zimbabwe. So he has failed to give us that evidence. So the shifting of the onus was also applied there. But there are several issues that come out of that case. So number one, the court correctly dealt with the issue of locus standi. Did Mangwana have locus standi to bring the case? So we held that it was a correct approach by the court. It was liberal. They applied section 86 of the Constitution, which is very clear. Abandoning, of course, it's no longer possible, the traditionalist restrictive approach. Then the issue of agency was also plausibly addressed by the court, and we are happy with that. The issue that brings a lot of issues is the issue of jurisdiction. Jurisdiction of the High Court and the Electoral Court. The court said that it had jurisdiction to hear the matter in terms of section 171 of the Constitution. So section 171 of the Constitution gives the High Court almost all the inherent jurisdiction to hear anything, right? Under that section, if you follow the reasoning of the judge, even the High Court can hear a labor case despite the labor court being there. It can hear an administrative case despite the administrative court there. So it took a very expansive interpretation of section 171 in a way that can make the electoral court a white elephant, right? If you read the electoral court sections on its jurisdiction, the framers of that act tried by all means to make sure that any electoral case, all electoral cases would come to it. But still, it seems that's not enough. There are several decisions of the High Court that says, no, the electoral court is the creature of statute, it can only do so and so, not this. Even if it's an electoral matter. So also for law reform, the issue of the jurisdiction of the electoral court must be revisited under the Electoral Act to see, do we want the electoral court to hear everything on election, despite the kind of order that is required or that is being sought, despite the nature of the application, the nature of the case, or anything. It must hear anything electoral. Why do we create a court and then deny it cases? To say that no, because it's a declarator. There is nothing in the rules of the electoral court that gives it power to determine a declarator. There's nothing. But this is an election case. It's an electoral case. Why did we create a court called electoral court? And then, did we envisage denying it some power as long as that case was what? Electoral. So I would want civil society to address that point. are the provisions of the Electoral Act good enough on the jurisdiction, especially when these greedy High Court judges are keen to use a section in the Constitution to say, we can do anything in terms of this section 171, right? So we found that I was not happy with the way the High Court addressed the issue of what? Jurisdiction, basing on section 171. Then on the issues as well, section 20, the residency qualification. There is no way that the residency qualification is restrictive, is exclusionary altogether. If you have a law in your country that says only these kind of people can stand for public office and not these, automatically it means those who don't qualify are excluded. So the debate is, are those provisions necessary? Are they justifiable limitations to standing for public office? There is to say a person must have been in Zimbabwe for the past 18 months, right? So we check also other practices, competitive practices. There are several countries with their own kind of limitations to public office, but most of them are centered on citizenship. If you're a citizen, you qualify. But now citizenship now being acquired because of birth or by descent, now there are also restrictions to say, if it's by descent, how many years should you have been a citizen? If it's by birth, it's automatic, right? So, exclusion on standing for public office on the basis of residence is one of the categories we have found across the world to apply. I want to say something. 1980, when the comrades were at war, right? They are coming from these assembly points. They were in the bush in Mozambique for more than 20 years, not 20 years, for a long time. These are the kind of provisions that would have made it difficult for them to stand in office. Because they would have been what? They would have been in the bush for 18 months or so, isn't it? Do we still need this kind of provision? Do we need this kind of provision that says 18 months he must have been in Zimbabwe for not more than 18 months? Do you think it's justifiable in a democratic society? Right. So just to go to the second case, the case of Leader Masarira, which was also a nomination case, but based on the problems encountered during paying the $20,000, which was the nomination fee for what? For standing for president, right? So I want to put a disclaimer. This case was not about the cost of the nomination fee, the USD 20,000. It was the challenges that were faced in trying to what? In trying to deposit that money. Did Linda submit documentation that showed that were required? Did she meet the requirements on submission of what? Of the papers, right? That were required. Despite whatever the court said, we found that this was a case where the court could actually comment on the USD 20,000. In my view, it's a steep fee. In any case, I had a chat with Prof. Matuko when this fee was gazetted. His office is next to my office, and I was like, Prof, how are we going to raise this money? It's a lot of money. I said, it's too much. I'm telling you, many people will fail to what? To pay this USD 20,000. I find USD 20,000 is extremely prohibitive of political participation, is extremely steep. It is so discriminatory, especially if you are a female presidential aspirant, considering the barriers that are there, that are faced by women in fundraising. The barriers that they face in addition to the barriers on fundraising. So we found that it is a very good argument. The court was not willing to accept the gender argument at all. There was a very clear statement by the court that we have to apply the law as it is, despite what? The gender of one of the parties. Which to me reflects that we have a problem with the judiciary. There are other issues that are so staggering in our society that even the judiciary itself cannot pay a blind eye. If they want to be inclusive, if they want to be responsive to social issues that characterize our political space. So we found that the Masarira case was a missed opportunity by the courts to try to give us good jurisprudence going forward. Then the next case, I will allow, I think one of my colleagues will go deeper on the Masara case, on the facts and also on the law. And the next case is the, the Elizabeth Valerio versus presiding officer case is also to do with the payment of the USD 20,000. Again, there was no jurisprudence on the steepness of the fee. The issue was whether the forms he had submitted met the provisions that required the particular documentation to constitute proof of payment. So the court ruled in a favor. So we found similarity with this case and the Masara case to say the elephant in the room was the USD 20,000. In a country with a multi-currency, in a country with a banking system that is suspicious, in a country where a person is likely to face problems if they pay on the final day or if they pay on the date in question, for the courts to just say, no, you should have done it even before, or why did you do it, to us was insensitive to the realities that we face in Zimbabwe every day. We thought even ZEC itself, in the case, in the Masara case, even ZEC itself issued a press statement kind of relaxing the requirement to say those who are affected by the banking challenges can come and then relaunch their papers, something like that. Despite the provisions of the law, kind of not anticipating such or not permitting that kind of approach, ZEC relaxed a bit, but the courts did not want to hear any of it. The court said they should have done it this way. So the Valerio case was decided in a favor, but we found that again, it's a missed opportunity in terms of jurisprudence. The courts must go deep in terms of these issues, right? It's an electoral code that is coming up. We need to create a lot of jurisprudence, deep jurisprudence, so that it can guide the conduct for future judges in the courts. Then the next case. Is it coming? The CCC versus ZEC, Soneni Moyo and others. This was a double candidates case whereby Triple C went to court to say those people who have been declared duly nominated are not our candidates. So we are appealing for them to be, not to be declared duly nominated or for them to be struck off as not being CC's candidates. So basically that was the case because it really felt that these are not its candidates. Do we have a law that allows a political party to say these are not our candidates? Please, they must be struck off, they must not be regarded as duly nominated, and ZEC must remove them. So this is the case that was before us. So the major issue for determination was a preliminary point that said, that is like whether or not the electoral court is exclusive and inherent jurisdiction to hear electoral matters or appeals. I had hinted at this point earlier on, and also whether or not CCC had the right to appeal in terms of section 46 subsection 19(1)b of the electoral code, of the electoral act. So our finding was that this is a case where the court went to town to say the electoral court has no jurisdiction, right? It has no inherent jurisdiction. It is only a creature of statute and it can only do what the statute does. So if the Electoral Act misses to say something, but it's an electoral issue, then it may not go before the electoral court. The electoral court can only do what the Electoral Act says and nothing else. So it means there are some election cases, electoral cases, that we have to go to the High Court because not everything has been given to the electoral court as some of these cases show. Then on the right of appeal, the sections that were used by the lawyers appeared wrong in that they did not give CCC the right to appeal to the electoral court to challenge the nomination of persons who they regarded as not being their candidates. So they used a section that required, that gave the right to appeal to a candidate, not to a political party. So the court did not do any purposive interpretation at all. It actually refused to say no. The provisions are very clear. We will impose and adjudicate based on what the letter of the law says. The letter of the law says a candidate is the one who must appeal in terms of section 46, subsection 19(1)b, not a political party. Now that we have a political party here, it cannot use the section that was used by its lawyers. Despite the case was thrown out on that basis, I found that the court was very correct because the provision that was used by the lawyers was wrong. It was very clear. I tried to put the provision. I think you can show it up. Yeah, the provision is very clear in that it can only be used by a candidate, where it says the candidate shall have this B. I think it's too small. The candidate shall have the right of appeal from such decision to a judge of the electoral court in chambers, and such judge might confirm, vary, or reverse the decision of the nomination officer. So they used this CCC to go to court and challenge the nomination of those ones that they said were not our candidates, and they lost. So on the literal grammatical meaning, on the strict application of this, that was the wrong procedure, right? So the issue that stood there in that case was that issue of the jurisdiction of the electoral court, and also the issue that they used the wrong procedure, which we agree with. But we found the judge here was very comprehensive. Went to town about even the arguments by the lawyers were quite extensive. They were very on point. They were very clear, right? We have also found that lawyers sometimes pick on these local standard technical points that don't even apply. And you wonder, why did the lawyers allege local standard in a clear case like this? Why did they use this jurisdiction? So this is a case where I thought that there was a mistake, there was an error on the part of the lawyers. They should not have used a section where that gave a right of appeal to the candidate. So these were the major cases that I studied. But from an overview of all the cases, they leave a bad taste, especially on the jurisdiction of the electoral court. Right? I think that more can be done on the jurisdiction of the electoral court. I am happy that the courts are, in the cases I checked, there's a movement towards addressing the substantive issues that are before the courts and not the technical issues, unless the technical issues are so patent, like this Sonenimo and others case whereby they use the wrong section to approach the court. Having said this, I want to leave this opportunity to my friend so that she can add to my sentiments. Thank you.
Thank you, Dr. James. Greetings to you all. I'd like to acknowledge the Executive Director of the ERC, and I'll ride on the protocol that she has already established in-house. Allow me to just single out Dr. Talisai Mutangi, who has also had a significant impact on my journey. So Dr. Talisai Mutangi, sir, I acknowledge you, and Dr. Innocent Maja, the Dean of the Faculty of Law, and I am a product of the Faculty of Law myself. I acknowledge you, Professor Maduku. It goes without saying, by and large, I will ride on the protocol already observed. This room is filled with great intellectual property, great intellectual resources, and I acknowledge that. I am in agreement with what Dr. James Tabora was talking about, that we find ourselves in a situation where the courts are now at like a vortex, where there's much litigation on electoral disputes, and that is not a bad thing, because it does bring clarity to the sections that are already existent and to the legal frameworks that are available. It becomes clearer what it is that we have to improve on and which trajectory we need to take in order to improve our jurisprudence as a nation. one of the things I just want to bring to the fore before I just delve into the cases, I'm only going to touch on 2 of the cases, which are the similar cases of Elizabeth Valerio and Linda Masarira. And my colleague Tinashe, who is coming after me, will deal with the remaining 2 cases. So I just wanted to bring to the fore that it's something to think about. As late or as early as 1868, this question was already being asked. 1868, which was well before Zimbabwe became a colony. There is a letter that Dr. Tarisai Mutangi brought to the attention of the the participants of the Law Society Summer School in 2023. In 1868, there was a letter that was written by the Lord Chief Justice of England to the Lord Chancellor. And the topic was the trial of elections. So this was a time when they were contemplating removing the trial of election petitions from another assembly to be done by the courts. And the Lord Chief Justice did not have kind words to say. He was of the view that this is a very tricky thing to do because men's passions will be burning, because people have choices. And when you give that burden to the courts, the trust of the public in the court will be diminished. It will be impaired because there will never be consensus. It's something to think about, you know, because even now we have jurisprudence that is coming out of the courts and it's a point of contention. It's a point of great contention. So it's not novel and it's not something that we're starting to look at now. This is something that was thought about as far back as 1868 to say, well, if we do choose the courts, because the courts are the most impartial body to deal with this, and if we do choose them, then we have to be ready that they might face a little bit of pushback because people's passions will be burning when these decisions come. So when the nomination court sat to receive nomination papers in 2023, several of the aspirants had difficulties paying the nomination fees. And like Dr. James Tabora said, this was possibly also owing to the exorbitant nature. So there were quite a lot of last-minute registrations because people were perhaps trying to raise these fees. And so it was 20,000 for the presidential candidates and 1,000 for the parliamentary candidates. So the difficulty arose because of delays in electronic payment systems, and ZEC published a notice extending the deadline. So ZEC noticed that we have a problem, and they published a notice. And this is what the notice read. It says, the Zimbabwe Electoral Commission has noted with concern reports to the effect that prospective candidates were disqualified from lodging their nomination papers on account of difficulties experienced in effecting payment of nomination fees, largely due to the current challenges within the banking system. In view of this, the Commission is calling upon all candidates and parties whose nomination papers had been submitted, but they had challenges with the payment. So funds maybe had not reflected in ZEC's account. And then they said, we're calling upon these who had lodged their applications to make necessary payments or get confirmation of the state payments no later than 1,700 hours on the 22nd of June. So this was an extension for those who had already begun their application, but they then faced challenges when they were making their payments. So we have 2 cases that are before us. And the case of, we'll start with Valerio, the case of Elizabeth Valerio versus the presiding officer. So both these women had challenges because their nomination papers were rejected on account of issues to do with payment. So with Elizabeth Valerio, right, on the nomination day, Ms. Valerio presented her nomination papers as a presidential candidate, together with a form from her bank, showing that she had instructed the bank to make a transfer, an RTGS transfer equivalent to 20,000 to ZEC. The form was signed, the form was stamped by the bank, and it contained a statement that the transfer instruction was irreversible. So the money had not reflected in Zek's bank account by 4 p.m. on the nomination day. And on that ground, her nomination was rejected. So that became her bone of contention. She then made this appeal because she was not happy that her nomination papers had been rejected despite her having done everything within her power to qualify. So the Electoral Court held that the bank form constituted valid proof of payment, even though the funds were yet to reflect. So she was covered by the notice that I just read. So the court held that Elizabeth Valerio qualified to register even though she had her payment had reflected later because of the extension that Zek had given. So her appeal was successful. And then we come to the case of Linda Masarira. So when Ms. Masarira submitted her nomination papers to the nomination court, she brought the transfer forms authorizing her bank to transfer the nomination fee in RTGS dollars into Zek's bank account. She filled the form, but she had not yet submitted the forms to the bank. So the presiding officer of the nomination court rejected the forms as proof of payment and advised her to use alternative transfer systems. And the alternative system did not allow large sums of money to be transferred. So she didn't manage to apply. She didn't manage to then comply with the payment of the fees because of this glitch that was happening, which was beyond her control. But the distinction only is that she had not yet gotten these papers stamped and signed. So this was the only distinction that was there. But she had already given her nomination papers, save for this payment, which then completes the payment. Because the nomination papers are submitted upon the payment. The payment completes the submission. So the court dismissed her appeal on the ground that she did not fall into any of the classes of candidates that were covered by Zek's notice. She had not presented the transfer forms to her bank, so she had not applied to make a transfer. Hence, on nomination day, she did not present the court with proof of payment of her nomination fee. She knew well before the nomination day the large sums of money could not be paid through alternative transfer systems. Well, the court basically was now saying that she did not substantially comply with what she was supposed to. And the rationale was that the nomination court is mandated. It is a peremptory provision. They cannot offer that indulgence. And now when you are now found without substantially complying with that section, the court then found that she could not be granted an opportunity to pay late. So the provision only applied to the defects in nomination papers, which was not the case here. That is what the court was saying. And though these two cases had different results, they were not necessarily contradictory. Ms. Valerio, well, this is what the court had said. So the court in the Valerio case said she had done all that she could to pay the nomination fee on the 21st, as opposed to Ms. Masarira, who had not. And the problem, which was over the nomination fees, would not even have arisen if that nomination fee was not exorbitant. So the question that we have today for the audience is, are these the kind of cases, or is this the kind of jurisprudence that we want to shape our election? We are saying the right to vote. Every person has that right. The right to participate is a right that is enshrined in the Constitution. I think we have had Professor Maduku, we have had Trust Maanda, we have had Honorable Monzora, we have had a panel, a full panel, and we've had presentations. Dr. James has touched on it, on the importance of the right to vote. You know, there's a case that I love where Justice Malaba, as he then was, said that the right to vote is a badge of freedom for a citizen. You know, it's a badge of freedom that everybody wears. It's your own badge of honor to show that you are a free person and you are able to participate in the matters that concern your nation. So is it enough for our courts to disenfranchise others, to exclude others from participation because of sections that we would have agreed on? So this is something for us to think about as we are talking about electoral reform. Who is the key player in all these situations? You know, when James was talking about the courts being the vortex, I just thought, wouldn't it be nice if there is a principle called the best interest of the voter principle? You know, just similar to how in children's cases, in every case applying to children, the best interest of the child are paramount. Wouldn't it be great if in every electoral case, the best interest of the voter is paramount? To say the court first exercises its mind, to say what is the best interest of the voter in this case, and they try by all means to guard the right to vote and to guard the right to participate in political and governance issues. So this is something for the House to deliberate on, and I'm just going to leave time to Tinashe, who's going to deal with the remaining two cases. Thank you.
Good afternoon, colleagues. I've been discriminated against. I've just been advised that in the interest of time, myself and Jake would have to do our presentations while seated. So, yeah. I will ride on the existing protocol, and I will go straight into the nub of the matter, as it were. I'm going to be looking at the cases of Labdel Mangwana versus Xavier Kasukwere, second Minister of Justice, as well as the case relating to the Bulawayo 12 CCC MPs, as that case is popularly known or colloquially known. I will start with the latter. The 12 CCC MPs case dealt with an application which were made. In fact, there were several applications which were made by various registered voters in several Bulawayo constituencies who were alleging that the nomination papers for the 12 CCC Bulawayo MPs, there were also other independent candidates and other political party candidates as well who were hit with those applications. The applications argued that they had presented their nomination papers after 4 p.m., which was in breach of the provisions of Section 46 of the Electoral Act, which required that the nomination papers be submitted by 4 p.m. on the day which was proclaimed to be the nomination day. So the High Court Bulawayo agreed and essentially held that the 12 CCC MPs and the other candidates as well had been invalidly nominated. It found that their nomination papers had been filed after the stipulated time of 4 p.m. In arriving at that holding, the court relied on the mere say-so by the applicants in their affidavits, as well as on what was termed to be a registration book, which haphazardly was used to log not the time that the papers were given to the nomination officers, but the time which those papers were processed. The 12 CCC MPs naturally appealed to the Supreme Court. I see that Gifts is here. He was one of those prospective MPs. And the Supreme Court came to a different conclusion. It firstly noted that the Zimbabwe Electoral Commission had in the High Court deposed two affidavits in which it stated that the nomination papers had been submitted on time. So the Supreme Court held that where the statutory body, in this case being ZEC, has submitted the report and adduced the evidence in court to the effect that the nomination papers has been submitted in time, the court could not ignore that evidence unless it was faced with stronger and more probative evidence to the contrary. So the High Court had simply relied on the mere say-so of those applicants who sought the disqualification of the prospective MPs. It had not relied on any other evidence to discard the clear evidence which had been adduced by ZEC. The Supreme Court also stated that where a statute, in this case the Electoral Act, gives an administrative authority powers to exercise certain functions, it is up to that administrative authority to determine how it will exercise those functions. In this case, the nomination officer had decided, because the courtroom was a small courtroom and it could only accommodate 12 to 15 people at any given point in time, he had decided that only 12 prospective candidates could access the courtroom at any given time, and after they had been attended to, the next page would come. So naturally, 4 p.m. Arrived, while the other prospective candidates were at the courthouse and were waiting to submit their papers, but they could not do so because there was a standing directive by the nomination officer. And so he directed that they hand over their papers to a police officer who was manning the court premises, so that he would then hand over to the nomination officer for the necessary formalities to be conducted. On appeal, an argument was then made that the Electoral Act required that the nomination papers be handed over to a nomination officer and not to a police officer. And the Supreme Court rejected that argument by stating that the power to receive nomination papers was reposed to the nomination officer by statute, and you could decide to let a police officer receive those papers if the exigencies of the situation so required. So the point which come out of the 12 CCC MP's case is that one would then need clear and cogent evidence when they are alleging that the nomination papers have been filed out of time. They would not need to rely on social media reports, and where ZEC is posted to affidavits or has provided other documentary evidence, courts would most likely rely on the evidence provided by ZEC. I will then move on to the more controversial one, Lafdell Mangwana versus Xavier Kaskwere, ZEC and the Minister of Justice. So the brief facts were that Mr. Mangwana approached the High Court. He alleged that Mr. Kasukuwere's nomination to be a presidential candidate was invalid. The invalidity stemming from the fact that, as he alleged, Mr. Kasukuwere had not been residing, had not been ordinarily resident in the country for a continuous period of 18 months, and therefore he was disqualified in terms of section, he was disqualified in terms of section 23 of the Electoral Act, as well as section 91 of the Constitution. Several technical objections were raised in the High Court. The first one being that of locus standi, being the right of Mr. Mangwana to approach the court and to seek the relief which he was seeking, which was basically the disqualification of Xavier Kasukuwere and the setting aside of his nomination as a candidate for the presidential election. The court adopted a liberal approach to locus standi and held that in terms of section 85, Mr. Mangwana was entitled to approach the court because he is a registered voter, though not necessarily registered in the same constituency as Xavier Kasukuwere. He was entitled to an election which complied with the legal provisions, an election which was lawful. Hence his allegation that the nomination of Mr. Kasukuwere was irregular entitled him to approach the court for relief. It would appear, or at least from where I'm standing, that the courts seem to take different views towards locus standi, perhaps informed by what would be convenient to them at any particular point in time. They would adopt a broad approach in the Kasukuwere case and hold that Lafdeo Mangwana had locus standi, but in the delimitation case, they would say you have no locus standi because you are not a National Assembly candidate. I think that was the very first case to be decided by the Constitutional Court in Jealous Mawari versus Robert Mugabe. The Constitutional Court actually said the court does not expect those whose hands are dripping with the blood of actual infringement of their rights to only approach the court, but anyone who is acting in the public interest. So it would appear where the circumstances are convenient, they broaden their understanding of locus standi, and where it's inconvenient to do so, they adopt a very narrow and strict approach. Another point which was also raised, also related to the jurisdiction of the High Court to deal with the matter. Mr. Kasukuwere essentially argued that the essence of Mr. Mangwana's application was an electoral matter, in respect of which the Electoral Court had exclusive jurisdiction. It was also argued that the application was a disguised application for review, which was disguised as an application for declaratory. And the court held that the Electoral Court does not have powers to issue declarators. So the court was properly engaged with the application, since the application was for a declarator, and also since the application on the face of it did not include any grounds for review. clearly stated that it was an application for a declarator. So what emerges there is that if in an electoral related matter, if the party seeks a declarator, then they are entitled to approach the High Court. So in future we may have a situation whereby litigants will circumvent the electoral court and make applications for declarators to the High Court on the basis of this authority. And on the substantive merits of the case, the court held that since Mr. Mangwana was alleging a negative, in the sense that Mr. Kazukwere had not been resident in the country for a continuous period of 18 months, the onus then shifted to Mr. Kazukwere to rebut that allegation. In normal court process, the principle is that the party which makes the allegation is the onus to prove that allegation. So if that cardinal rule of process been followed, it would have meant that Mr. Mangwana needed to prove that Mr. Kazukwere was not in the country for a continuous period of 18 months. The court then held that Mr. Kazukwere, by admitting that he had been temporarily absent from the country in order to seek medical attention, he had failed to discharge or to rebut that allegation, and accordingly found that he was absent for a continuous period of 18 months, and therefore his nomination fell foul of Section 23 of the Electoral Act, and as well as Section 91 of the Constitution. His nomination was therefore set aside, and other ancillary relief was granted. He appealed to the Supreme Court, and the Supreme Court essentially upheld the decision of the High Court. But what both the High Court and the Supreme Court did not deal with was the fact as to whether temporary absence, for whatever reason, can be taken to mean that a person is no longer ordinarily resident in their constituents for a continuous period of 18 months. In other authorities, the High Court has held that temporary absence does not affect one's status as ordinarily resident in any particular kind of place. The same was also stated by the Constitutional Court in Mtuma Mawere versus the Registrar General, where the court held that the fact that a person can be living in another jurisdiction does not affect their status as being ordinarily resident in the country. What both the Supreme Court and the High Court did in the Kazukwere case was to just give a perfunctory dealing with the concept of ordinary residence. More so when regard should be paid to the fact that the right to stand for public office is constitutionally enshrined in terms of Section 67 of the Constitution, and that when dealing with rights which are entrenched in the Constitution, any other thing which has the effect of limiting those rights must be strictly and narrowly construed. One would feel that by adopting that perfunctory and almost casual approach to the issue of residence, both the High Court and the Supreme Court really did not do much justice. It would just leave room for anyone to say on the next election, so and so is not ordinarily a resident in Zimbabwe and has not been so for the last 18 months. And that is all. They don't need to prove anything because it was stated that it's a negative. So the onus has to shift to the person who has been nominated as a candidate. The other issue which arose also is that the Supreme Court actually made a holding that where it has been found that a person has not been resident or ordinarily resident in a constituency for a period of 18 months, then they automatically cease to be a registered voter. They arrived at this conclusion, notwithstanding the fact that the Electoral Act has clear and specific procedures which must be taken for a person to be removed from the voters' roll. But what the position which was taken by this Supreme Court seems to suggest that Mr. Kasukwere ceased to be registered as a voter once the finding that he was not ordinarily resident in the country for the past for a continuous period of 18 months was met. Yeah, I think that will be all. I will defer to Jackie.
Thank you very much. Good afternoon, ladies and gentlemen. Allow me to write on the protocol already observed and to thank the director of ERC for convening this symposium and for allowing me to be a part of it. I have been requested to speak while sitting and to limit my presentation to 8 minutes. I refuse that discriminatory instruction. Ngiyalile, ngifuna la ukuya ku-podium so that I can send pictures to my family. Right. So we are discussing this very important aspect of the role of the judiciary in resolving electoral disputes. To this end, an independent judiciary is paramount for democratic processes to fully function. Court judgments in electoral disputes have an impact on the perceived legitimacy of an election. So when we are looking at the role of the judiciary, it goes to the core of governance issues in a country. Because the reason why people go to vote and the reason why citizens are interested in voting is because it goes to the root of governance issues and the management of national resources. And you find that Zimbabweans are very, very passionate about elections. They are passionate about voting, and it seems that on a daily basis, they are engaged on issues to do with national governance. It's because they feel that there is a problem, and as such, these issues spill over into the courtrooms every now and again, or every electoral cycle. We see that these courts are seized with electoral disputes. Judges or the judiciary plays a significant role in ensuring the peaceful resolution of election disputes which end up in the courts. And this is a way of also preventing people resorting to self-help. So in exercising their duty or in exercising their role in resolving electoral disputes, the bench always has to be aware that their decisions have an impact on the environment prevailing in the country. If the bench is considered not to be adequate in resolving electoral disputes, you will see that this can lead to post or pre-election violence or violence during the election season because people are not satisfied that the courts are able to handle election disputes. So judges are then meant to be impartial. They are meant to be appointed in a non-partisan manner. They are not subject to electoral processes. They are not elected by anyone. And they have security of tenure. And they are expected to adjudicate upon electoral processes freely and without fear or favor. So, to this end, their independence is enshrined in Section 164 of the Constitution and is meant to be guaranteed in several ways, including the manner of appointment. I think Dr. Tabora and I, we met during the ZEC selection process. So we were locked up in Parliament, in the old Parliament, the whole day. And because our surnames follow each other's T and S, we were there until the night. From morning to evening, we were waiting to be interviewed. And this is deemed to be like transparent, and we're being beamed live on TV. The interviews were live on TV. They were being broadcast live during that that day. And we've seen it just ended a selection of judges. I think Professor Maduku alluded to the selection of judges, which has just ended. And how this is supposed to be an impartial process, a professional process. There's supposed to be accountability in terms of who is chosen, because this is a bearing when it comes to such issues like electoral disputes, which are then expected to be dispensed of in a very objective and transparent manner, and in a way that promotes constitutionalism and promotes the exercise of democracy. So it's in the manner of their appointment, the security of tenure, their pecks and remunerations. This should also be issues of public knowledge. What are they entitled to? It is important, and it has a bearing, particularly when it comes to issues of electoral disputes. So, because the stakes are high when it comes to electoral disputes, you will notice with the Lovedale Mangwana case, the stakes were pretty high. It's pretty much the equivalent of the Jacob Zuma participation just in the South African elections, with the ruling party significantly affected by the participation of President Jacob Zuma in that election under the banner of Umkhonto Sizwe. So you find out the stakes are high, and it involves those who are already in power. It involves the ruling party, it involves those who are in administration already. And it would seem, like Professor Maduku said, that constitutions are there to guarantee against abuse of power. Every one of us, if we get the taste of power, we will want to abuse it. We will want it not to end. Power is sweet. We want it to last forever. We want more and more and more. That is why there are constitutions which are put in place in every organization, in particular, more importantly, more so for a country, you require a constitution to safeguard against potential abuse. And even if you think my candidate is an angel, and once they get power, they will be so angelic and kind to him, you'll be surprised about the things they will do when they get into power. So that is why it is important to have an independent judiciary, and an independent judiciary which seeks to uphold constitutionalism and protection of human rights. Courts are expected to act as umpires and referees. They're not expected to act as players in the match, because that then creates problems. It means that there is no one, there is no objective person, or there's no objective institution to call for order when chaos descends. You know, when there are two committing individuals or entities, it can easily degenerate into a chaos. There will be, it will be a voice match, a war of words, or even actual war. In Zimbabwe, we've had violent elections before, very, very violent. People being killed just because we want to choose person or the people or the party which you want to get into power. So it can get very chaotic, and as such, in the absence of an independent judiciary, there will be no one, or there will be no institution left to resolve electoral crises of such a nature. And to this end, judges must not then be afraid to make decisions which do not sit well with the administration that is in power. And if you look at the recently mentioned cases, you see that there is no consistency in, I think Tinashe is the one who went into the Labdo Mangwana case, in famous Bulawayo 12 case, and how there is lack of consistency in application of the law. And I believe that this creates a problematic jurisprudence because well, there are a number of learned courts work on precedents, and that jurisprudence which has been created today will apply even 20 years from